while it feels like a lifetime ago, given, the current news cycle, it has not even been a month since the United States Supreme Court ruled that Donald Trump is entitled to substantial immunity from prosecution for alleged crimes committed involving core official presidential acts, effectively placing him and other U.S. presidents above the law. Now, while we await the impact of that controversial ruling on several criminal cases pending against Trump, we're getting new insight into how the conservative majority at the Supreme Court came to its 6-3 decision. CNN reporting today that Chief Justice John Roberts, who previously has been able to broker compromises, made no serious effort to entice the three liberal justices for even a modicum of the cross-ideological agreement that distinguished such presidential power cases in the past. People close to justices in the far right told CNN those justices were heartened by Roberts after years of suspicions about his efforts at the center of the bench. According to CNN, all told, Roberts appears to have reached a turning point. Joining me now, Melissa Murray, MSNBC legal analyst and co-host of the podcast Strict Scrutiny. My friend, it is good to see you. Are you at all surprised by the reporting I just shared?
I'm not at all surprised by the reporting, Alicia, but I was one of those people who for years had noted that despite being raised in the crucible of the conservative legal movement, John Roberts, as Chief Justice, had really proven himself to be something of an institutionalist. He sided with the liberals on some key abortion cases. He was the lone conservative who refused to overrule Roe versus Wade in Dobbs. But there seems to be a limit to that institutionalism. This case, the immunity case, took a long time. That seemed to have been by design. The court waited until April 25th to hear oral argument and then waited until the very last day of the term to announce a decision, which, according to Joan Biskupik, who reported this, seemed to compress the amount of time for negotiations. And that compression was really meaningful because it seems clear that Chief Justice Roberts was not interested in negotiating, that he was interested in brokering a sweeping grant of immunity, and he wasn't interested in any kind of compromise. That, to me, was actually a real surprise, because I thought the amount of time the court was taking to decide this case was because the Chief Justice was trying to get everyone on board for some kind of a unanimous decision, and that would require some time to work out. It turns out they were just running out the clock. There was no compromise to be negotiated. Chief Justice Roberts wanted an imperial presidency, and it seems like he got himself one.
I want you to help me understand, Melissa, this reporting in the context of this speech yesterday. You had President Biden laying out proposals for Supreme Court reforms, mandatory ethics rules, 18-year term limits, a constitutional amendment that would overturn the court's ruling on presidential immunity. Just given the insights that we are getting into this court, I wonder how we should be thinking about those reforms.
Well, they're obviously urgent and necessary. This is a court with a 6-3 conservative supermajority, and it will be a conservative 6-3 supermajority for some time, which means that they have broad power to do what they like, and they have been doing what they like. They've had the 6-3 conservative supermajority for about 3 years, and in each of those 3 years, this court has overruled a major precedent. Dobbs in 2022, the affirmative action cases in 2023, and this year they overruled Chevron. And I would argue with the immunity decision, they overruled some of the earlier precedents limiting presidential immunity in certain contexts. So this is a court that's sort of bent on doing what it wants, and it does need reining in. And to be clear, I'm not clear that the president's proposal for Supreme Court reform is going to get a lot of traction in this election year. But I think what it does signal is that the Democrats are no longer putting this on the back burner. They are running on the court. They recognize that this court is an impediment to any kind of progress that elected officials can make in their domestic agendas going forward. If they pass something in Congress, this is the court that will unravel it in the courts. So they need to address the court. They need to address this imbalance of the court, and they need to do it sooner rather than later.
Well, just to articulate that point, this week you had Iowa becoming the latest state to ban abortion after 6 weeks. They joined 21 other states. You can see it on the map there that either ban or severely restrict the procedure. Iowa ban, as you know, it has exceptions. But like many other states, those exceptions, they are purposefully vague. They are designed to have a chilling effect. The thing I want you to help me understand is, are there legal remedies for this, or are the solutions largely political?
Well, Well, going forward, it seems like this will be a political fight. It will not necessarily be a legal fight. I will note that the Iowa Supreme Court that upheld this ban did so on a 4-3 basis. It was a very narrow decision with the Chief Justice, who is a Republican, voting in dissent here, saying that this law should not have been upheld. So it's a very narrow law. I think Iowans can vote to change their state constitution to provide more impressive and robust protections for reproductive freedoms. That's something that's happened in other states. In states where you have the prospect of ballot initiatives or voter referenda, you can use direct democracy to achieve some of these things. But this is largely going to move from the legal realm to the political realm. And here's where I think Iowans do have an advantage. This question of reproductive freedom enjoys majority support in Iowa. The reason it can't get through the legislature is because the legislature is so gerrymandered such that Iowa legislators don't actually have to be responsive to their constituents. If you can address the gerrymandering and the distortion in the electoral landscape, then the people can actually have their preferences reflected in representative government. Until then, you're going to have to see a lot of these machinations, maybe direct democracy, maybe a constitutional amendment.
Melissa Murray, as always, thank you so much for being with us tonight.